Hey everybody, how's it going? Welcome back to Copper Jacket TV. So the FPC made a pretty big move yesterday against the approved handgun roster. This is the case of Granata V Healey. We're going to be talking about the details today and exactly what the FPC did, so let's get to it. This video is sponsored by EuroOptic, which in my opinion is one of the best websites on the internet. If you haven't been to EuroOptic, I suggest you do it. They have everything from optics to gear to all the tools of the trade for your 2A fun, everything. And there's no games. They are veteran owned, located in Pennsylvania, and they don't do drop shipping, which is where you order it from the website, but a week later it ships out from a distributor or somebody else. If it shows in stock on the EuroOptic's website, it's because they actually have it in stock and it ships same day. Everything ships same day. Plus, they also have red label shipping, and if you see that and you're able to acquire that, it is 1 to 2 day shipping for free. So everything on the website ships same day. Some of the stuff is going to arrive at your door in as early as 2 days. So EuroOptic, for all of your 2A needs, that is absolutely the only place to go. So check it out. Now, I think some of you might be surprised to find out that there's more than one state out there that has something as stupid as a handgun roster. California obviously has theirs. It's probably the worst. It's been frozen in time. People are still stuck with their Gen 3s, and there's a pretty big lawsuit trying to overturn that one. This is Granata V Healey. Now, this would still have an effect on California's roster, but this one is out of Massachusetts. Massachusetts has one as well, and it puts a pretty big restriction on people's Second Amendment rights, just like in California. So now I want to talk to you guys about what the FPC did just yesterday that would be the big game changer in this case, because this case, believe it or not, was already dismissed and on appeal. So I'm going to put something up on the screen so you guys can kind of read along with me. But if you look at the bottom right there, you'll see that the complaint was originally filed on the 8th of June 2021, and then right after that there was a motion to dismiss by the defendants obviously being the state of Massachusetts, right? And then on the 19th of May is the memorandum and order defendants, motion to dismiss plaintiff's complaint allowed. And then the FPC and Granata notice of appeal. So they appeal it on June 15th of this year. And this is the thing that actually might break it all wide open. And that is the plaintiff's motion for vacatur and remand. So what does that mean? So what that means is that the FPC and Granata are saying to the state that we want you to vacate that previous order, the dismissal. We want you to vacate that and remand it. We want you basically to do it over again. Now, in their pretty lengthy statement as to why this should be done, Bruin is used as a prime reason because this happened prior to the Bruin decision, right? So the dismissal came prior to Bruin. Now, in Bruin, it says that you can no longer use the two-step approach when you're, talking about Second Amendment related cases. You have to use text, history, and tradition. So they didn't do that in Massachusetts. What they did is they used the two-step approach, trying to balance the state's interests over people's Second Amendment rights. And that is expressly forbidden in Bruin. So when Justice Thomas came out and said that you have to use text, history, and tradition, he said you can no longer use that two-step approach. So the approach and the process that was used to come up with the original decision in this case is now null and void. And that's what they're trying to say. They're trying to say that you used a process that is not acceptable. This is the process that should be used. We want you to take that decision. We want you to basically get rid of it. And we want you to do it over in light of the Bruin decision. And since the Bruin decision is so clear, there is pretty much no other way that you could see this case other than being a violation of our Second Amendment rights. In FPC's statement, it basically says that there is no historical context for an approved roster or an approved list. If we go back in time in the nation's history from, the ratification of the Second Amendment in 1791 and we move forward, to the 1860s, you can't find anything within that time period where the state has a mandated issued roster. And since that doesn't exist, again, by Supreme Court decision, then the law, such as this roster, can no longer exist as well. Now, when I say that this would have broader implications like California has a case, Granata V Bonta, and that is currently challenging California's roster, and that case is moving forward as well. But if this case were to be vacated, remanded, and then we get a win in this case, then they can use that as precedent to say, hey, look, another circuit court already found that it was unconstitutional based on the Bruin decision, found that it was unconstitutional in text, history, and tradition, And so they can use that as precedent in the California case, saying that, you know, we already have one circuit court that came up with this decision, found it to be unconstitutional, and this is the reason why moving forward. So this could actually assist the Rena v. Bonta case in California, which could be a really big deal. It's basically like a domino effect, right? And that's kind of what happened with this Bruen decision. Bruen basically, I mean, destroyed gun control altogether. If you took a look at everything that these states like to pass, they always use the two-step approach. They always try and balance, you know, government's interest and public safety over people's rights, and that's no longer acceptable. If it didn't exist in the past, then that law cannot exist in the present. And that's what Bruen did. And so I see a lot of challenges like this coming forward in the future, but this would be a nice win, and based on what we see in Bruen again, and the letter that I read from the plaintiffs, I'm going to say that there's probably going to be a win here in Massachusetts, and if that happens, I think we're going to see a win in California as well. So again, that was a pretty big step. It wasn't just, you know, a regular appeal. They're asking for it to be completely vacated, which is, again, that's actually a pretty big movement. So I wanted to make you guys aware of that. I want to thank you all very much for watching. If you wouldn't mind, please like, subscribe. You guys have a great day.